prayer for stay of the operation of my notice of termination was not considered.
June.
My lord, I am by operation of this notice of termination, I will be out of service, my lord, on 25th of May, despite the fact that I insisted upon consideration of my stay.
Just let us go through. So are you working there?
My lord, I am working in Mathabhanga Government Polytechnic, my lord. My letter of termination says I have been given 1 month's notice for termination, my lord. By operation of this notice, my lord, my services will be terminated.
What is your grievance?
My lord, this I am suffering from physical disability, my lord. I possess valid certificate of disability issued by statutory authority under Right of Person with Disability Act 2016. Prior to that, my lord, I was issued certificates under the previous acts as well. My lord, my disability is of varying nature, so my lord, my certificates are temporarily issued. Because my lord, my disability.
Show us your last certificate.
My lord, my last certificate, my lord, is at page number 671 of your lordship's brief, my lord. But my lord, that is a bit illegible, so my lord, I have prepared fresh copies, my lord, for your lordship.
Give us.
But 3 of my certificates are, my lord, stapled together. My lord, because the recruitment process was, my lord, in 2018. So, my lord, at that time, I had this certificate. The first.
Why you are saying it is a varying disability?
Because, my lord, my percentage of disability, my lord,
It was 50% at that time.
it was 40% in 2004.
First certificate.
First certificate, my lord, of 2004.
40,000 in 2004.
My lord.
2005.
2005.
And then it became 50% in 2019.
19, my lord.
19.
19.
And then
My lord, in 24, it was again adjudged to be 40%, my lord. It is valid till 2029.
40% where do you find?
My lord, at my lord C, point number C, my lord, he has 40% temporary disability relation to his or her.
So this is valid till April 2009.
29, my lord.
Very good. Now what is the problem?
My lord,
Commission
based on this
commission recommendation, which page?
My lord, commission's recommendation, my lord, I was not provided, but my lord, appointment letter is there.
To us.
My lord, the appointment letter, my lord, is at page number, my lord, 179, my lord. My lord, only 79. Only 79.
Huh?
79. My appointment letter, my lord.
This is of 2021.
21.
When were you appointed?
My lord, I appeared in the selection process in 2018. Selection process was concluded in 2021. My lord, thereafter I joined in December 2021. After that, my lord, I was asked to appear for medical examination in 2022, September 2022.
And in that medical examination, you are found to be below 40%.
My lord, in that medical examination, I was found to be below 40%. That, my lord, was handed over to me in the administrative tribunal on 13th of May. I have annexed that as well, my lord.
Was
My lord, that report.
that was not earlier given to you?
No, my lord.
31st of May 24.
My lord, 13th of May 24.
24.
My lord, when the matter was heard by the tribunal.
13th of May.
13th of May. This, my lord, 13th of May.
It was handed over to
My
you.
lord, it was handed over to me in the course of the hearing. Column says unfit on account of below 40% disability.
But you are not having below 40%.
According to my
medical board which examined you, where is that report?
My lord, this medical
13th
board
of
report.
May.
My lord, that report is at page 108, my lord. It was handed over to me on 13th of May. It was examined. I was examined
What
on
was it
2020.
determined to be?
My lord, kindly take up, my lord, second last line, my lord. Unfit on account of below 40% disability, it says.
So this varies with the certificate which you have placed.
The statutory certificate, my lord, which have been issued by the statutory authorities under the relevant act.
Now in the advertisement notification, it was there that below 40% will be disentitled.
But in the advertisement notification, it says that clause number 9 said that a person having a certificate of disability issued.
Where page?
My lord. But the advertisement, my lord, is at page number 72, my lord. And my lord, the relevant clause is at
72.
My lord. It starts at page 72. The lordship will kindly see, my lord, column number 2, electrical engineering. There are 2 seats reserved for locomotive disability candidate. My lord, I applied against that 2 seats, my lord. My lord, electrical engineering, my lord. This was, my lord, advertisement for lecturers in government polytechnics. And my lord, kindly takes up page number 75. My lord, clause number 9, towards the bottom portion, my lord, it says, for person with disability, a medical board constituted at
After reading,
my lord, clause number 9, my lord, just above clause number 10. My lord, at the bottom part of page number 75, my lord.
is the rule that
But I
it
have-
has to be below 40%.
My lord, the West Bengal Service Rules, Rule 10 says, my lord, a person possessing a certificate of disability will apply. My lord, the West,
Below 40%.
No, what my brother is asking.
Is the
According to the government, below 40% disability will be rejected.
my lord,
On what basis are they saying that?
my lord, Rule 10 of the West Bengal Service Rule says,
Yes,
my lord, subject to provisions of Rule 11 and
Then
of
you are
any
reading
special
that-
rules regulating, my lord,
10 is Delhi and
my lord, not this rule, my lord, West Bengal Service Rule, my lord, as it fell from your lordship, according to government, the disability will be rejected. My lord,
this is a guideline.
my lord, this is the 99 rules which is there in the advertisement, my lord, which your lordship just read, my lord.
That is for the purpose who will be the competent authority.
And my lord, who will adjudicate, my lord? Yes, my lord. The certificate of
We are
disability.
wanting to see the embargo under the West Bengal
My lord.
service rule.
My lord, I
Below
only-
40% will be disentitled.
my lord, that in my humble submission is not the language of
So
the.
where from they are getting this clause?
My lord,
This is totally wrong then.
my lord, kindly, my lord, see the rules, my lord. এটা একটু করুন।
What have you found? What is the requirement?
My lord, the requirement is only the certificate of disability, my lord.
আবার বলে disability.
The medical certificate of fitness issued by the competent authority subject to other rules. You know, that is the rule 10. You know, that is
And in the guideline, it says if there is any dispute as regards the
there
percentage,
is the appellate board, my lord, under rule
it is
7.
a appellate. That is rule 10.
Rule 7, my lord, of the guidelines.
ওইটা বইটা দাও।
This rule 10 is also quoted, my lord, in my notice of termination.
traveling allowed.
My lord, rule 10, my lord, any person, it is mandated by the West Bengal Service Rule that no person shall be appointed in a post without medical certificate. Here, Sudarshan Guria belongs 40%.
You are reading, sir.
My lord, my lord, your lordship asked where it is quoted. My lord, in my notice of termination, my lord,
Notice of termination, page 105.
105.
Which paragraph are you reading?
My lord, the third last paragraph, my lord.
Third paragraph begins in on receipt of report of the medical examination.
My lord, third last paragraph, my lord. Whereas it is mandated
Huh.
by the West Bengal Service Rule that no person shall be appointed in a post without a medical certificate. My lord, the percentage of disability, my lord, in my humble submission is not there in the rules, which, my lord, they are quoting now. And my lord, I have a valid medical certificate issued by the competent authority under these rules, which is
What
not.
interim order you are praying for?
My lord, I am praying for stay of the operation of this notice of termination because my services will be terminated on and from 24th of May by operation of this notice.
24th of
May 2024, my lord. My lord, this notice was for
it
1
will
month,
become effective.
my lord.
So what interim order you have prayed for? Show us.
My lord. But I am, my lord, interim order, my lord, is at page number 39 of my lord, my
H to K.
Permit order to correct.
You are working where now?
but I am working at Government Polytechnic Mathabhanga as a lecturer of electrical engineering. Mathabhanga, Kuch Bihar.
Permit order.
Yes, Mr. Mukherjee.
Order. Matter has been fixed for hearing. Matter has been fixed for hearing in the month of June. 10 June. Number one. Number two. Termination order cannot be stayed by the court.
No, we will ask you. You don't disturb his service till it is.
No order. If order today,
If today we don't interfere, then he gets terminated.
but your lordship will get that. If he succeeds in the original application,
He will be brought back.
yes, he will be given all benefits. And my lord, kindly do not take it otherwise. My lord dealt with the same point,
Yes,
dismissing, rejecting my contention.
complied.
No, my lord, SLP has been admitted, order has been stayed by the Supreme Court
Yes.
in a similar case.
Show us that.
You have got the act.
My lord, I have got the act and my lord, I have got
2015
that judgment as well, my lord, which my learned senior friend is relying upon.
If
But this judgment was passed in, my lord, on February 2nd. My lord, as has been rightly stated, my lord, the order has been temporarily stayed pending adjudication of medical disability from AIMS Delhi.
Oh, I see.
My lord, it has not been set aside as yet, my lord. So, my lord, this order is,
So to find out actually what medical condition the person is.
my lord. And my lord, I have talked with, my lord, the set of advocates who are appearing, my lord. The Honorable Supreme Court, my lord, gave two options, either to argue on the basis of your lordship's findings that this authority or the subsequent finding of disability is completely bad in law without jurisdiction, as your lordship held, or to get
Get tested.
tested and then come and argue all points.
Oh, that is why you thought it will be better to go for a medical.
My lord, I was not there, my lord. I have spoken to my, my lord.
They reported হয়েছে?
Yes, my lord. I'll hand over a copy.
But
Lord-
that was on a different issue. That
Lord,
was
say-
whether
The same issue, my lord, the percentage
here
was,
the state government will not appoint with any person below 40% issue was not there.
my lord, yes,
No,
my lord.
but same thing.
That was, my
Lord,
lord, there in
he
the
has got
advertisement,
medical
here it is not
certificate.
there.
He has got medical certificate. Then for after selection, he was sent for medical exemption. Then the apex body, Calcutta Medical College, found that unfit because he
Below
got
40.
below 40%.
So where is that provision that below 40% nobody can appoint it?
Under the statute 2016 Act.
Show us
2016 Act. কোথায় আছে?
My lord, in that play, my lord, in that judgment which, my lord, I have just placed before your lordship, paragraph 16 record,
in our
my lord, yes, my lord, your lordships recorded in paragraph 16 that the advertisement itself recorded that it will be subject to medical verification. My lord, in my case, my lord, advertisement does not record that. My lord, my appointment letter says that my appointment is pending the medical examination by the competent board and pending police verification report. My lord, and then the consequence is given. If police verification report is adverse, then my appointment will be terminated. No consequence is given for medical examination. My lord, may I place? My lord, it's a very interesting thing in my appointment letter.
Rule 10, subject to the provisions of Rule 11 and any of the
What a place.
special rules related to this recruitment. No
Another
person
copy,
can be appointed to post government service without medical certificate of
Where
fitness.
you are reading?
My lord, he is
Rule
reading
10,
Rule 10 of
Rule
West
10
Bengal
of the West
Service,
Bengal Service Rules.
which I just placed before your lordships.
Rule 10 of the West Bengal Service Rules.
In this case, the medical examination in the advertisement was this clause.
The clause, paragraph 16 of your lordships order, my lord, your lordships have
In
recorded.
your case, the clause is for persons with disabilities.
That-
That medical board constituted at Government Medical College Hospital in Kolkata, district and subdivision. This clause was also there in that.
My lord, that my lord, paragraph 15, my lord, of that your lordship's judgment. My lord, both these clauses were there. In my case, the second clause is absent. The second clause, my lord, is in somewhat there in my appointment letter.
Whether I will write
Lord,
appointment
if I may
letter or
place-
not, two things is compulsory. One is police verification report and medical exemption by a competent medical board. And competent medical board does not mean my lord, that he must be a expert in the subject. But
No, that competent medical board you have mentioned in the advertisement.
but also medical board bullet here to be for the apex body, Calcutta Medical College.
That in the advertisement.
There is no such mentioning.
Not there.
So you are on that ground we decided against you.
Yes, and that judgment has been stayed by the Supreme Court.
Stayed not for the reason that it is going to be records have been called for from you. It is stayed on the ground since an option was given to the petitioner. Will he argue on merits or he
No, that
will
will be
go for-
decided by the Supreme Court.
So that does not create an embargo.
No, I'm not saying that. But I'm just giving the proposition of law that medical board examination is a compulsory in any government employee, even High Court employee or Lord Judiciary, even a teacher. Before appointment, medical exemption and police verification. If there is something wrong, then if he is not medically unfit, he has been declared to be medically unfit. But can the court say, no, you are a medically fit? It's an apex body.
My lord, the statute does not provide so, my lord, subject to correction.
Where
But the
is
rule
this-
said so.
Mr. Mukherjee, you have said it is mandated by the service rules that no person shall be appointed below 40%.
No, dear concede.
Where is that?
Rule 10 of the WBSR.
But I just placed, my lord, the book is there, my lord, before.
This one.
My lord, I have flagged mark it.
What does your subject to provision? Without a medical certificate, where is the 40% bar?
and my lord, subject to any special rules as well. My lord, that is the 99 rules.
99 rule.
My lord, I just handed over this Calcutta Gazette, my lord.
In that which clause you are referring?
Clause number 5, my lord, of that rules. And my lord, that is quoted in my advertisement as well.
দাঁড়াও, go slow. You gave it to us.
My lord,
কোথায় রাখো? Which clause you are?
clause 5 of that rules, my lord.
5.
My lord, it says medical board. My lord, the medical board shall be, after the examination, give a permanent disability certificate in cases of such permanent disability where there are no chances of variation. And then clause 2, which under which I am covered, medical board shall indicate the period of validity in the certificate in cases where there is any chance of variation in the degree of disability. No refusal of disability certificate, my lord, shall be made unless an opportunity is given to the applicant of being heard on representation by the applicant. The medical board may review its decision having regard to all the facts and circumstances of the case and pass such order in the matter as it thinks fit.
There is no provision that below 40% will not be eligible.
My lord, below 40%, my lord, is the benchmark, as my lord has been
Yes.
considered, my lord, by the statute, my lord.
So below 40%, nobody can be.
I will not be issued certificate of disability, my lord. If my disability, my lord, is below 40%, I would not be considered as a physically handicapped person. I would not be issued, my lord, a certificate of disability, which, my lord, I possess 3 certificates, my lord, by different competent medical boards under the statute. So, my lord, the authority under the garb of this medical examination is not disputing my pre-existing certificate of disability, but, my lord, is sitting in appeal by way of an executive order under the statutory board, my lord, which is not permissible in law, my lord, as per.
Under the statutory?
My lord, under the statutory rules, my lord, there is no option of being sitting in appeal by the recruiting agency. Recruiting agency has to accept that certificate. My lord, that is also there in the current rules of rule 2017. My lord, it says that a certificate issued under this 2017 rule has to be considered as valid for all purposes. Is issue of certificate of disability.
Rule
18, my lord. Firstly, rule 18 says by which method, my lord, certificate of disability will be issued. Your lordships. And my lord, then rule 19 says certificates issued under rule 18 to be generally valid for all purposes. My lord, a person to whom the certificate issued under rule 18 shall be entitled to apply for facilities, concessions and benefits admissible for persons with disabilities under schemes of the government and non-government organizations funded by the government. So, my lord, I am, my lord, to use this certificate of disability, which I just handed over to you, lordship.
in your appointment letter, it was specified by them.
Lord,
that it can be in your appointment letter, that clause was added. Was that clause?
My lord, lord, appointment letter, my lord, is at page number 17.
Which Mr. Mukherjee is citing? Page
79.
Page 79.
My lord, it just says, my lord, clause 3 of my appointment letter.
Yes.
The above appointment is made provisionally for a period of 1 year from the date of joining the post of lecturer at the concerned polytechnic mentioned at column 4 of the table above, pending receipt of medical examination and report of verification of antecedents and character by police authorities concerned. Then, my lord, is the consequence. In case the PVR, police verification report in respect of any candidate is found to be unsatisfactory by the concerned police authorities, the appointment in respect of the candidate is liable to be terminated forthwith without issuing any notice. So, my lord, the consequence of medical examination, my lord, in my humble submission, is not provided by the appointment letter. And, my lord, the validity of medical certificate is only to be ascertained. My lord, the percentage of disability, the statute already provides who will be the competent authority and who will be the appellate authority. My lord, the recruiting agency is neither nor the competent authority, my lord, under the statute, nor the appointing authority. In fact, my lord, statute says that my certificate has to be used by me for all the benefits which is available to any physical disability persons. So, my lord, the authority by way of an appointment letter cannot override, my lord, the statute in my humble submission.
Oh, it has not overridden.
My lord, it has sat in appeal over my certificate of disability.
No, that is not indicated in your appointment letter. You will not be granted appointed if your PVR is wrong.
My lord, that has.
There is no provision that it will be medical certificate. You have to undergo a fresh medical certificate in spite of the clause provided under the notification. But why Mr. Mukherjee is submitting that a next medical verification is possible? Whether your certificate is genuine or not, it can be ascertained. but the quantum of disability cannot be redetermined. That is your context.
That is, my lord. I'm grateful, my lord.
So far as the proposition of law is concerned by my landfund, that or not. But medical exemption is a compulsory. And medical exemptions under Rule 10, if it is found unsuitable or unfit for medical government service, then he cannot be continuing the service.
So that Mr. Mukherjee, this new medical board to which he has been sent, as stated in
No,
the
but can you see two things? Appointment, disability certificate, one board, and medical board for medical exemptions in one board. There are this medical board under the 2016
no such
statute.
provision in the advertisement notification.
No,
You are
it
saying
is not necessary because of the rule said so.
which rule said so?
Rule 309, framed under 309, West Bengal Service Rule, Rule 10.
Yes, where is the percentage of disability?
Right, percent of disability will be determined by the
By the medical board.
no, by the legislature. That is, field of legislation is the parliament, not by the state government.
Oh, benchmark is 40%. Now you have found it to be 38%.
No, Madam, can you see the
The new medical board has found it to be 38%.
below 40%?
That is below 40%.
Below
So
40%.
where is that you have stated in your appointment letter and advertisement that you will be subjected to a fresh medical test, and in that case, if it is below benchmark, you will not be.
No, that cannot be. That is impossible.
Why?
Because rules framed under Article 309 that there must be a medical exemption,
Of the act.
a medical board, and police verification report. Two things. Then medical board, this is the certificate issued by the medical board, not by the 2016 Act. This is a medical board under the service rules. Whether his person is fit for service or not. He has been declared to be unfit for this service. Whether the court exercising tutorial, no, this medical board opinion is incorrect. I am putting the question to myself.
So you will not, the rules which were existing, you are saying that you have a right to medically assess him
Yes.
prior to giving him appointment.
Prior
That
to
is the-
appointment or even after appointment.
So where in the appointment letter you have said that if the medical report is against you or contrary to the certificate which you have given, we will not appoint you.
No. Can you pending receipt of the medical report? Can you see the language? Pending.
Pending receipt of medical examination
Pending means
and report of verification.
and
Read
report.
the next clause.
Yes.
And of the candidate by the competent
And
medical
character police
now,
verification report of
in
the
case the PVR in respect of an is found
by
unsatisfactory,
the candidates by the competent medical board. Can my landlord say this is not a competent medical board?
My lord, I'm saying that.
competent medical board, all right. We are asking you a question, Mr. Mukherjee, where is that line? That if the disability is found to be less,
Disability is tested by another 2016 Act. What should be the disability percentage? 40%, 60%, 80%, 100%. But what should be the medical fitness that will be tested by the medical board to be appointed by the government? And they are not the ordinary persons, they are the expert in the subject.
so those who assessed him, they were also experts, Mr. Mukherjee.
No, it is the Central Medical Board, apex body.
Central medical.
Central Medical Board. Can you see the advertisement?
But if it is a varying you are admitting it is a varying medical disability. So there is every possibility that it may has come down to 38%.
But my lord, on the date of my application, my lord, I was suffering from a 40% disability. My lord, that is, my
So
lord,
if it has improved,
my lord.
your test was conducted at the time of advertisement, that was in 2005. We are in 2024. Your last certificate was issued in the year 2024, where it was set 40% temporary. So next test was after that, and therein your ability has come down to 38%. Once it is 38%, you are not entitled.
Percentage, my lord, is not there. And my lord,
Percentage is
but in the 100 page number 108, my lord, which your lordship just saw, my lord, just written unfit below 40% disability. And my lord,
Medically unfit.
108 unfit on account of below 40%.
my lord, the certificate of disability, my lord, which I possessed on the date of application was a valid certificate of disability.
Forget
My lord,
about
then, my
date
lord,
of application.
2022, 4 years after, and 1 year after I joined,
Possibility of the disability having decreased cannot be ruled out.
but that will not make me disentitled for service, my lord, till the time I possess, my lord, a valid certificate of disability. My lord, then again in 2024, I have a certificate of disability saying that I have 40% disability, which is valid till 2029. So, my lord, my percentage, my lord, as it fell from your lordship, may have decreased. My lord, that does not change my identity as a physically handicapped person. My lord, my bench, my lord, I am physically handicapped person.
Come under the regards of the rules. Rule says that below 40% it cannot be.
But my lord, prior to 2022 and even after 2022, my lord, I have been issued a certificate of disability. 22, when I appear for medical examination, my lord kindly takes up the memo at page 99. It says, my lord, Dr. such and such is appointed to adjudicate the percentage of disability in 2022, adjudicate the percentage of disability prior to joining of service. So, my lord, the doctor sitting in 2022 has to decide what was my percentage of disability in 2021.
Very
My lord, kindly see, my lord, page 99, my lord, bottom portion, a handwritten thing is there, forwarded to Dr. A. Basu, Ortho Department, for verification of percentage disability prior to joining in government service. My lord, may I ask a question to myself, my lord, how a doctor, my lord, can certify my disability which was there prior to my joining of service? Or, my lord, the relevant period will be prior to, at the time when I applied for the service, my lord, because that time, my lord, my certificate was a valid certificate. My lord, I applied in 2018. My lord, can a doctor, my lord, have this expertise? When specifically, my lord, my disability is of varying nature. My lord, I am questioning, my lord, even the jurisdiction as well as, my lord, the prudence of this certificate. Because one, my lord, the statutory rules does not prescribe or does not authorize, my lord, these medical boards of recruiting agencies to, my lord, reassess my percentage of disability. It
Then
has,
what you say about the stay which is being granted for the purpose of re-medical examination?
my lord, that, my lord, in the case facts of those cases, my lord, Supreme Court, my lord, it's fell from the vision of Supreme Court, my lord, to reassess that person. My lord, even if, my lord, your lordships send me for another medical examination, my lord, I am ready to go. But, my lord, my point of jurisdiction, my lord, may kindly be kept open, my lord. Because, my lord, another judgment, my lord, by this honorable court was decided by Honorable Justice Aniruddha Bose, as his lordship then was, my lord, in 2010. My lord, it was very detailed judgment questioning the authority of West Bengal, my lord, the West Bengal, in service field of education, West Bengal Regional Service Commission's authority to re-verify, my lord, the percentage of disability.
by
He
10th of
will-
June.
We understand that, but he will be out of service. Mr.
No, Kanshi. If termination order is set aside by the terminal, he will get all financial benefits.
Mr. Mukherjee, can that be a ground for denial of
But
interim
it's not order of termination. Kanshi.
termination to be given effect to within a month?
But yes, sorry. Today, if
So you suppose today
what is the case? He applied under the disability quota. According to 100% roster, he has applied. On the basis of the online applications, he is applied with the 2005 certificate. And when it was tested,
the present application has been preferred, challenging an order to
25th of April 2000.
13th of May 2024, passed by the learned tribunal in the original application being way at
তারপরে হবে, কালকে পড়তে দিয়েছে, হতেই পারে না।
by the said order, though the application was admitted by the tribunal, the interim order as prayed for was refused.
It was not even considered, my lord.
By
Said order, the application was admitted by the tribunal.
no, did you make a prayer for interim?
My lord, I made, my lord, I placed several insistence, my lord.
আচ্ছা, তাহলে এরম লেখা
I have even pleaded it in my writ petition.
original application such as preferred an order against past
Challenging
in a
Original
Is it-
original
অবস্থা।
The original stop on next. Mr. Mr. Singh, learned advocate appearing for the petitioner submits that in course of hearing before the learned tribunal on 13th of May 2024, an interim order was prayed for, but such prayer was not considered. And aggrieved thereby, the petitioner has approached this court. He submits that challenging an order of challenging a memo dated 25th of April 2024 issued by the respondent number issued by the respondent number 2 submits that the
Submits that challenging a
No,
memo
it's- submits that upon emerging to be successful in a selection process initiated pre advertisement number 24 2018, the petitioner was appointed to the post of appointed to the post of
Lecturer, my lord, of electrical engineering in
where it is taken
In a politics,
page number
appointed
79.
provisionally to the post of lecturer in electrical engineering of Government Polytechnic. Government Polytechnic,
My lord, my particular post, my lord, is there at the annexure. My lord, annexure to the appointment letter. My lord, that is at page 87, my lord. Total 101 persons were given appointed, my lord.
where you are posted?
My lord, page 86, page 87, my lord, government Polytechnic Matha Bhanga.
Appointed to the post of lecturer, provisionally appointed to the post of lecturer in electrical engineering at Mathabhanga Government Polytechnic, Kuch Bihar. Read a memo dated 26th of October 2020. This contains that upon emerging the petitioner was appointed to the post of such
ধীরে মেমো এত
video memo. And he is working in the said post till date. By the impugned memo dated by the respondent number 2 thereafter issued a memo dated 25th April 2024 intimating that the petitioner's appointment has been terminated and the notice should be treated as 1 month's notice of termination. The period of 1 month would be expiring on 24th of May 2024. And the next date of hearing has been fixed before the learned tribunal on
10th of June, my lord.
on 10th of June 2024. In the said conspectus, if the petitioner is denied an interim protection, he would suffer irreparable loss. He argues that the petitioner is suffering from physical disability and he participated in the selection process on the basis of the on the basis of a certificate issued by the competent authority as detailed under clause 9 of the advertisement, being the basis of which This is certificate issued by whom?
My lord, the first certificate, my lord, was issued by Haldia Subdivisional Hospital. Medical Board of Haldia Subdivisional Hospital.
By the medical, by কি লিখলেন?
Participate in the selection process on the basis of a certificate issued by the competent authority as detailed under clause 9 of the advertisement being
Being being the medical board of Holdia Subdivisional Hospital, wherein it was certified that the petitioner suffers from 40% disability. Subsequent thereto, the petitioner's physical disability was reassessed and a certificate was issued by the same medical board on 13th March 2019, reiterating that certifying that at the relevant point of time he was suffering from 50% disability. And lastly, a certificate has been issued by the medical board of the
That would be, my lord, competent authority of Nandigram Super Speciality Hospital.
by the medical board
Lord, it's
By the-
competent authority, my lord.
by-
Under the new rules, my lord,
by the
competent authority under the of the Nandigram Super Speciality Hospital.
by the competent authority of the Nandigram Super Speciality Hospital, indicating that the petitioner was suffering from 40% disability, and the said certificate was recommended for 5 years, and would be valid till 16th of April 2029. Let the certificates as produced be kept on record. According to Mr. Singh, the petitioner, according to Mr. Singh, the petitioner fulfilled the terms of appointment, fulfilled the disability percentage at the time of appointment, and the same has been, and such disability has also been certified by the competent authority of last one,
My lord, the Nandigram Super Speciality Hospital.
super specialty is also valid till 5 years. Surprisingly, the petitioner was asked to appear before a medical board as indicated in the appointment letter.
But by a memo dated 8th of September, I was asked, my lord. That is by a memo dated 8th of September 2022, almost 10 months after my appointment. My lord, page number 89, my lord.
Read a memo dated 89 কোথাও কারেকশন করার সময় a memo dated 8 September 2022, and the petitioner was intimated that, where is that report?
My lord, the report of medical board, my lord. My lord, it has page number 108, my lord.
Wherein it was stated that the petitioner was quote unquote unfit on account of below 40% disability. Mr. Singh argues that he said such certification has been made sitting in appeal over the earlier certification issued by the competent authority, and such process as adopted is alien to the provisions of the statute. Next, Mr. Mukherjee learned AGP learned advocate appearing for the state respondents submits that in the appointment letter itself it was specified that the petitioner has to appear before a competent medical board, and on the basis of assessment of his disability by the said board, the petitioner was found to be unfit, and accordingly the order of termination was issued. In the event the petitioner finally succeeds, he would, needless to observe, in the event the petitioner finally succeeds, he would become entitled to all consequential reliefs. Had the learned advocates appearing for the respective parties and considered the materials on record, it appears that at the time, it appears that the petitioner it appears at the time of it appears that the petitioner at the time of selection fulfilled all the eligibility criteria and was having a valid medical certificate issued by the competent board. After appointment, the petitioner's disability has been reassessed and the percentage of disability after appointment, the medical certificate issued at page 108 sitting in appeal over the earlier medical certificate. Stop. In the event from the impugned notice, it appears that his petitioner's termination would be effective from 24th of May 2024. And prima facie, in our opinion, the refusal of the interim order would cause more prejudice to the petitioner than the absence thereof is likely to be caused to the respondents, more so when the petitioner is in service since
2021, December
Since-
2021.
since the month of December 2021.
21 or 20?
2021, Milord.
2020. So December 2020. In view thereof, there shall be an interim order restraining the respondents from interfering with the service of the petitioner in the post of lecturer
Lecturer
at
of-
Mathabhanga such and such, till the date of till disposal of the original application. With the above observations and directions, the writ petition is disposed of. There shall have been no address to course urgent certified copy. Needless to observe, the matter would be finally decided by the learned tribunal without being influenced by the observations made in the present order towards grant of an interim,
Milord, may I seek one more indulgence, Milord?
as expeditiously as possible. We would request the learned tribunal to finally decide the original application as expeditiously as possible. As expeditiously as possible, either on the returnable date, no, as expeditiously as possible without granting any unnecessary
Milord, may I
adjournment
seek,
to
Milord,
either
one
of
more
the
indulgence,
parties.
Milord? Milord, I obtained a leave to file this writ petition without certified copy. Milord, in the meantime, I have obtained the certified copy. Milord, I have handed over a copy to your lordships.
Let the original certified copy as placed be kept on. ওটা তো দেওয়া দরকার না, সার্টিফাইড কপি রেকর্ডে রেখে
I'm grateful, Milord.
তাহলে লিখে দাও, let the certified copy of the order impugned as produced by Mr. Singh be kept on. তাই মিস্টার মুখার্জি একটা দিয়েছিল না কাগজ, ওটা কি ফেরত দিয়ে দিলে? ওই রুলটা স্টেটের রুল। Mr. Mukherjee, you have taken back the rule which you gave.
No, no.
This, Milord,
No, no, rule.
No, Mr. Mukherjee gave us. হ্যাঁ, হ্যাঁ, থাকুক। We will give it back to you after. We are reading, this is your.
No, Milord.
Yes, next call.
Grateful.
কি হলো?
Item number 1, your lordship has been